Hey everybody, it's Adam here. This is the 15th week of a 15-week session. Hope you'll pardon me, but I'm kind of fried. It's been long days, and it's going to be more long days until April 28th. The way it looks, we're not going to get out of here on time. There is likely to be a special session, so stay tuned. More about that in a minute. There's a couple things I want to talk about. One is the bill that I'm most actively working on, have been for about the past week and a half. And that's got to do with drunk driving. Then I want to talk to you about the budget, and in particular the beer tax, which I believe ought to be used to fund our drunk driving campaign. We're going to put a whole lot of people in either alcohol treatment, where I think we have the most effect, or in some cases jail, where alcohol treatment has not been effective. I believe those are necessary to protect the public. We've had a couple of major incidents involving drunk driving over the past month in Seattle. And I believe that we need to ramp up our two-pronged approach to this. Alcohol treatment is absolutely the most essential form of crime reduction. We need to put more money in it. It doesn't have the kind of satisfying clang of the jail doors that some of my colleagues kind of like. But it's the most effective way to get drunks off the road or have them not drink. That's going to be my personal campaign, is to make sure that the bill that comes out of here in the next few days has adequate requirements and adequate funding for drug treatment, and usually in this case it's alcohol treatment. Let me go over some of the particulars, just sort of run through this. This is the bill. It's pretty thick. It's 80 or so pages. So I'm just going to go through some of the highlights. Major changes in public safety sometimes sound a little technical, but here they go. First of all, we've been allowing the judges to defer sentences. I think there is something to be said for that. If a person is going to get a deferred sentence, that means they're on an effective probation for a period of time, usually a year, during which if they screw up, they go back to jail, and they know that. So there's something to be said for that. The problem is that in those deferred sentences, we too often do not monitor the person to know whether they're on good behavior, not drinking, and so forth. There's a judgment here that deferred sentences are not a good idea. I'm willing to go with that experimentally. We may revisit that situation. In determining whether a drunk driver has prior drunk driving convictions, such that they can be considered priors for purposes of sentencing. In the past, we have not counted a negligent driving, even though it may have been pled down from an initial charge of drunk driving. We're going to start doing that. In negligent driving, we'll look in the file. If that was originally charged as a DUI, it will be scored as a prior for purposes of sentencing on a subsequent DUI. And let's talk about those sentences. We're not going to go after the first offender. Very often, the first offender is somebody who drank a little bit too much wine at a party, won't do it again, is absolutely horrified at being pulled over by a police officer. That's about 80 or 90% of the DUIs. It's a first offender, it's a mistake, they got it, you're not going to do it again, thank you and goodbye. Pay your fine, do your 2 days, that's all. We're going to leave it at that. It's the second and third and fourth, and yes, there are sixth and seventh and eighth offenders. Those are the people who cause most of the fatal collisions in the state. Those are the population we need to go after. We're going to use our scarce resources to go after those guys, leave the first offenders pretty much alone. Second offense, instead of maybe 7 days in jail, it's going to be 6 months if the blood alcohol reading was less than 0.15. Remember, 0.08 is the minimum. 0.05 means you almost have double that. It's pretty high. If you do have above 0.05, the mandatory minimum is 364 days. Used to be called 12 months, and it was 1 year for purposes of federal law. We don't want people deported because of this, and if you happen to be a non-documented citizen, don't worry, you won't be deported because we're keeping the 364 rather than 365. The feds don't consider that deportable. But remember, we're talking heavy sentences. 6 months if it's below 0.15, 364 days if it's above 0.15. But you get a choice. You can do no additional jail time other than the real mandatory minimum, which is 10 days, if you do what they do in North Dakota. You have a choice. You can go to jail and spend your time, or you can go through professional alcohol treatment, serious alcohol treatment, not to be confused with alcohol information school. 3 afternoons, you study, you take little notes and you pretend to be very interested. No, this is serious, personally confrontative alcohol drug treatment. You have to raise your hand, admit to yourself that you're an addict, and get serious about it. That may be harder for some people than the jail time. Most people, I think, will take the treatment, but there are some who would rather do the jail time, and I understand why. This is self-confrontation. And, by the way, when you're on alcohol treatment for the following 2 years, you will wear a bracelet that is going to be designed to allow the local police to know if you are drinking. It's a transdermal, don't get me on the science of this, all right? It's a substance that senses the sweat in your arm and can tell that you've been drinking. There's some alcohol content in that. All right, don't get me on that. It will be attached to a cell phone device, effectively, that radios or telephones that to a central location where people are watching, and you will be visited, okay? You'll also have an interlock device on your car, and we'll get to that later. Treating that interlock device is mandatory, checking on it, make sure it's on the car, we're going to do that. Third and fourth offense in 7 years. Now what this will get you, 364 days mandatory minimum. Yes, you will have the option of drug treatment if you have not had it prior. If you have had it prior and it hasn't worked, you're going to spend some serious time in jail. 364 days, that's the mandatory minimum. Fifth offense in 10 years is treated as a felony. It is currently a felony. We're not changing that. We're not creating more felonies. What we are also doing, though, is leaving the felony level at the 5th in 10 years. We're going to add some aggravating factors. The police have asked us for this one. It seems to be a common event in very heavy alcoholics that they're found driving the wrong way on not just residential streets, but wrong way on like a freeway. What they're asking for is a head-on collision, much more dangerous. We're talking about combined speeds of 2 vehicles being a resulting speed of 100, 120 miles an hour. People get killed that way, and so we're going to add it as an aggravating factor, meaning it's a Class C felony now. The Class C felony maximum is 5 years. The judge can then give you up to 5 years. Having a passenger under the age of 16 in the car. First offense, it's an extra day. Remember, we're not being hard on the first offenders. Second offense, it's 5 extra days, and this is not part of the thing you can waive. You're going to serve this time. Third or fourth offense, it's 10 extra days. You can't waive that. That's not part of your choice to go to treatment. Supervision. Part of the problem in one of the DUI fatalities that we had in Seattle was a guy who had tampered with or refused to put on his interlock device in his car. Nobody was watching. We are going to have a monitoring squad. It'll be attached to the State Patrol, non-uniformed, not commissioned officers. We're going to make sure that people have that on them. And we are going to have Department of Corrections supervision for the felony DUIs. We scaled back, for financial reasons, the funding of DOC, Department of Corrections supervisors. And low risk to reoffend, we took them off supervision altogether. DUIs are treated as if they were low risk, but we're talking about 5th and subsequent offenders. These are not low risk. We're putting them back under DOC supervision. It's going to cost, but I believe it's money well spent. Those who refuse to take the breathalyzer test, we take your license, that's current law. We're going to do more. First offense, It's a $500 infraction. It's not a felony, it's an infraction. Second offense, it's a gross misdemeanor. It will get you up to 364 days in jail, local jail. We are going to get more serious about those people who believe somehow that they have a right to refuse to take the breathalyzer test. In fact, they've given their implied consent by simply having a driver's license using the highways. You've effectively consented to a breath test. Well, we're going to make it either an infraction the first time or a gross misdemeanor any subsequent time if you do that. Here's the heavy one. Forfeiting the vehicle, not the license, not taking the license, taking the car of the person who removes an interlock device, as that guy did in one of the 2 Seattle incidents. You're not just violating a court order. You are clearly a person who needs to be watched. You're under court order to have that interlock device in your car. You tamper with it, you remove it, or you simply refuse to have it on after warning. I'm sorry, take the car. At some point, we're talking about people who, I understand that alcoholism is a disease, it is a sickness, but it's not a cold, it's not leukemia. There is an element of personal choice in this. And we are going to provide treatment first and foremost. We're focusing now on people who have effectively refused treatment. This is, I believe, draconian, and I can't say I oppose it. Some of the things that we're doing here cost money. Let's talk about how we fund this. My Republican friends don't feel apparently any great need to fund this. Apparently government services are for free. I didn't know that. I'm going to suggest either of 2 ways to fund it. One is the beer tax, and I have an amendment to this bill that will continue the beer tax at its current rate. Let me tell you, that's not the sales tax. This is a tax over and above the sales tax. I don't like the tax myself. I brew my own beer. I drink beer. I like good beer. I'm very, very friendly to the small brewers. And I purposely want to keep the beer tax in the way it is. It has a limit, 60,000 barrels per year of production, which effectively means that microbreweries, as we know them, do not pay a high rate. They pay a much lower rate. The only 2 breweries, I'm sorry to say, I can't name them, but there are 2 breweries in our state, you know them. Maybe you drink their beer too, like I do. But they are the only ones in state that are going to pay it. The other breweries that import from out of state, that make more than 60,000 barrels a year, they will also pay it. And I can assure you they're not happy. The microbreweries ought to be happy because we're not going to do what either the House bill would do, which is to raise the tax on them, nor what the governor would do, which is to take out that 60,000 limit and have them pay the same tax as the big boys. They really hate that. I'm going to keep the 60,000 barrel limit so that only the current tax is paid by the microbreweries. I don't like taxing microbreweries. I drink their beer. I really appreciate real beer as opposed to that beer-flavored water that you get from some of the big boys. Folks, we need the revenue. We don't have any money around here. This is a revenue source that is connected to driving while intoxicated. Now, usually there's been some studies of the people pulled over for DUI. There was an academic study, yeah. 72% reported beer as the intoxicants. Of the other 28%, 18 said it was hard liquor, only 10% said it was wine. There is a nexus, in other words, for this tax between beer and DUI. Now, granted, it's probably the usual cheap fizz that gets most people who are DUIs high, but all right, we need the revenue. I'm sorry, that's just the way it is. So that's one alternative. The other alternative is liquor, hard liquor. Only responsible for 18% of the DUIs, but the liquor industry is more accustomed to being taxed. They don't seem to have the same opposition to it. In fact, we're getting signals from their industry association that say, okay, no problem. Remember, you pay more for a bottle of liquor than a bottle of wine or beer, and so that tax is less noticeable. In any case, we have to fund it. My Republican friends literally do not want to fund it. They have no problem, with one exception. There was one Republican who signed on to my bill. It's Senate Bill 5915. It has one Republican signatory. I'm looking for votes. I have a hard time with this because, remember, we're in the minority now, and there's 25 of them, only 24 of us. They have this religion about no new taxes, and they don't want to violate their religion. So this may be hard going. I don't predict success for this. I do predict a long, hard battle on my part, and I can assure you that I want to do the best by public safety, and I want to pay for it. That makes me kind of a loner around here this year. Hey, thanks. You take care.